Good morning, good afternoon, and good evening, wherever you are. It's 11 o'clock in London, so I'm going to start. Just to have a little bit of housekeeping, um, we're trying this on Teams webinar. We've tried it a few times and it seems to work, and hopefully the technology will be there. There is a Q&A function, and towards the end, certainly do provide any questions, because I'm hoping to have some time towards the end to answer those questions. We think we've done it, set it up in a way that it should be anonymized, and so you don't necessarily have to be named as your question, but if you're worried about it, by all means, have a try first. So, welcome and thank you for joining me on this webinar, which is, we've called it Lifting the Bonnet on Tender Stage EPC Reviews. And whilst it's been advertised as Lifting the Bonnet, it's a bit more about getting inside my head. And what this does is, what I'm about to share is to reflect how I approach EPC contract reviews at the tender stage. It's not a universal method, but rather a distillation of over 20 years of experience in international construction law, from reviewing, drafting and negotiating EPC contracts to providing project advice, and ultimately to resolving disputes under EPC contracts, often in international arbitration. And over the years, I've reviewed scores, possibly hundreds of EPC contracts, and that has given me a particular vantage point on how these contracts are drafted, where they tend to go wrong, and what patterns emerge across sectors. And it's from that vantage point that I've developed my own checklist of starting points, mental shortcuts and red flags that help me quickly to assess a contract shape, its risk profile, and drafting quality. So a quick overview of the webinar. I've given you the introduction, and I will talk a little bit more about what this is. Then we're going to set the scene. We'll get into my top 10, and then hopefully we'll have time for some Q&A at the end. And I'm certainly looking to complete it within the hour. Now, even though this is scheduled for an hour, that's tight. I think, especially when you consider that I regularly, annually give an introductory seminar in EPC contracts to describe what they are, and that runs close to an hour in itself. And I've also designed courses on negotiation and drafting EPC contracts that can span 3, 4, or even 5 days. So this isn't a substitute for a detailed review or comprehensive training, and there is no substitute for that. And you'll probably hear me say this several times during the webinar. But what I wanted to share with you is a set of my own, essentially personal heuristics, the key indicators that I look for early when reviewing an EPC contract for the first time. Now that gives me a sense of the contract structure, the risk profile, drafting quality, and a guide to where I should be focusing my attention as I go through. And the intention is very much focused on the practical. And so hopefully you'll have some immediate takeaways from this. Now, the question is, what is an EPC contract? It's helpful to cover this quickly at the beginning, because when we talk about EPC contracts, obviously that's engineering, procurement and construction, we're not referring to a single fixed type of contract. For instance, in the power sector, EPC often implies full commissioning and performance guarantees, but it's also used in the infrastructure sector, and that might be closer to a design build model with fewer turnkey obligations. And the label EPC doesn't always tell you what you're getting inside the tin. So rather, from my view, EPC is best understood as a concept shaped by commercial expectations and funding structures. And it means different things to different people, and its application varies across industries, jurisdictions, and project models. But at its core, the EPC model is about single point responsibility, I think. The contractor is undertaking to deliver a fully functioning facility meeting specified performance criteria for a fixed price and by a fixed date. But this structure didn't emerge in a vacuum. In fact, it's a creature coming out of that was created out of project finance. Lenders required certainty of cost, certainty of completion, and most importantly, certainty of financial return. And so the EPC model has evolved to meet those demands, allocating most of the project risk to contractors to make the contractor, as they say, bankable. And that's why EPC contracts in their purest form are primarily concerned with risk allocation and financial logic, rather than engineering or construction, as you might see in a more conventional contract. And that's also why, when reviewing them, you require not only legal fluency, but also an understanding of the commercial and financial context in which they operate. Now, on the slide behind me is how I try to depict it. The construction, the engineering aspects of these projects, and the projects themselves are quite amorphous. They're constantly moving. Whereas the EPC model is to try and fit those in as much as you can into a box with certainty, with clear sides. But to provide certainty, you need clear drafting. Now, to give you a sense of scale, I've been doing this for 20 odd years, and it still takes me a first time read through of an EPC contract anywhere between 4 and 8 hours. That's a first read. As a rule of thumb, generally a full review with comments and suggested drafting amendments takes around 40 hours, depending on the complexity and scope, and a more high level review somewhere in the middle, around 20 hours. But this isn't just about time. These EPC contracts are complex instruments, and reviewing them properly means understanding not just the legal language, but, as I said, the commercial and technical context. Now, when I was preparing this webinar, it's ultimately one of the hardest things I've actually had to do. Not only was it to come up with a top 10, but also to work out what those top 10s are and why. And this is because it's identifying my own heuristics, rather than all of the substantive points that are important. And more importantly, why do they matter? Why do I do this in this way? And in this way, I often think of Bent Flerberg's book about how things get done, which explores the idea of experience, which is the combination of experience and expertise. And it's only when you've been doing this for a long time can you actually do certain things become obvious through repetition and reflection. Now, out of the 10 points that I'm going to pick up, you might find yourself thinking, well, obviously. And that's very much the point. These are things that now seem intuitive to me, but only after many, many years of work. But also, it's about clarity of thought and what I describe as smart thinking. It's not about just diving in right at the beginning, because that's the natural tendency. The natural tendency we all have is to pick up a contract and start at the beginning and work your way through. But is that the best way? I don't think so. And that's not the way in which I work, and certainly not the way in which you can assess risk. And there are shortcuts to do this. There's an English expression about kicking the tires. It's about doing an initial scan of the contract, looking for the specific indicators that will shape how I'll actually approach the detailed review. What is standing out? What's missing? What's particularly complex? And from which perspective? And has it been drafted from an employer-led position, from a lender-led position, from a contractor-led position? And this talk is intended to apply across the board. To the employers, or in certain industries they're called owners. I'm going to keep saying I'm going to refer to them as the employer just for simplicity. There is contractors, there is insurers, there is funders, there is consultants. Now, before we dive in, technology can help. There are some great tools out there, and I use them and have used them in the past. Things like Contract Companion, which isn't in itself AI, but uses a rule-based logic to analyze documents. But there are also emerging AI-based tools that can assist in working through checklists. And again, I've seen this done a lot more. But the nature of AI is it is a probabilistic model, and you still need to check whether or not it's going in the right direction. And that's where you have the experience. Now, my substantive checklist is well over 50 items. But the ones that I've chosen to share today are the ones that I think bring me the most immediate turns at the beginning. And why does this matter? because it's not just about reviewing everything line by line. It's knowing where to look, what to question, and from a lawyer's point of view, how I can add value. It's not just about spotting drafting flaws, which you still need to look at. It's about being able to help the users to make informed decisions and avoid tracks. Now, turning to my top 10, this is intentionally general and is of general application. Now, every type of project has different substantive issues to look for. For example, I have a specific offshore construction checklist. I have another power one, because each of those will have different features. But this, I think, hopefully is of general application. And the starting point is to treat every contract as different. Now, finally, before I actually get into the top 10, it perhaps goes without saying, but at least one of the earliest things that I look at is the governing law clause, and often combined with the jurisdiction clause to provide the legal context. But I think that should go without saying. Now, number one, how long? Or should that be how long? Now, when I get a contract, I might dive in straight away and have a look at the governing law clause, but I'll simply go back and have a look at the page count, because it can be very illustrative. Now, I have a theory that it should be possible to draft the conditions of any EPC contract in under 100 pages, given sufficient time, sufficient cooperation, collaboration of the parties, and also sufficient confidence as to where you're going. It's not a hard and fast rule, but it's a very useful benchmark. Now, 110 to 120 pages is common and usually fine. Anywhere over 150 pages, I think that's a red flag. It suggests that things have become overcomplicated or over-engineered. There may be poor drafting discipline. There may be a lack of confidence. There may be a lack of time. Now, length in itself doesn't determine quality, but it often correlates with how well the contract has been thought through. An excessive length can signal duplication, superfluous causes, unnecessary complexity, and often the legacy of amending amended precedents, or a single lack of thought in risk allocation. It also affects usability. Longer contracts are harder to navigate, harder to manage, and are more prone to inconsistency. But length equally can be a product of increased certainty, but not always so. Length can also invoke the law of unintended consequences. Now, in 2, what I've said is don't judge a book by its cover. Having had a look at the page numbers, I'll have a look at the contents page. Now, again, sounds pretty obvious, but actually a proper review of the contents page can be deceptively revealing. And it's not just to navigate the document, it's to get a sense of how the contract has been structured. At its simplest, does the contents page match the actual structure of the contract? Now, the number of times I have picked up a contract, looked at the contract page, turned it over, and it's only when you start, certainly in the past, only when you start reading through the contract, you think, hang on a minute, where have these headings come from? And you realize that the contents page hasn't been updated in that way. And so it's a very simple task, and it sounds quite administrative, but it's a very simple task to make sure that you've got that contents page, an accurate contract, because it sets out a checklist and a tick point that you can go through to make sure when you're doing your detailed review that you've worked through it. But also a quick comparison of the contents page with known standard forms like FIDIC and Logic can give you an indication as to where the origins of this contract was, or at least where it was intended to be, or indeed whether or not it's a bespoke, or I call a bespoke EPC contract. And where we talk about bespoke contracts, and many people have heard me say this before, that these bespoke contracts are not drafted brand new from a blank bit of paper. They're often in-house precedents, either from clients or from their own lawyers. But again, over time, an orthodoxy has developed as to the different clause headings that you can expect to say. So when you're looking at this, I can see almost immediately whether or not it's based on a FIDIC contract, whether or not it's based on a Logic contract, or a different form, for example. But again, this should mean you shouldn't be lulled into this false sense of security, because I've seen what seemed to be, in terms of a contents page of a lightly amended standard form, only to discover that they've been fundamentally rewritten beneath the service once you get in. But again, it gives you that starting point, and it also gives you the way in which to approach it. And the third one is the definitions. Again, this may all seem really obvious, but again, definitions, certainly in complex EPC contracts, can be the first 20, if not more, of an EPC contract, 20 or more pages of an EPC contract. And it's tempted to start on page 1 and to read through those first 20 pages. That's not how I do it. And that's, everybody has a different approach, but I don't do it that way. My first approach is to extract the definitions. I'll either print them out or I'll put them into a separate document. And then I'll refer to them as we'll go through, and I'll tick them off. Now, once I've gone through and worked through the substantive clauses and looked at the definitions as they come back, I will then, having read the whole contract, read the definitions in full. Why do I do this? Because the definitions will only make sense in context, and reading them in isolation can be misleading. And some definitions might look on their face of them to be quite innocuous, but often they can be loaded with risk once you get into how they're being used within the conditions. In terms like completion, defect, force majeure, applicable law, all of these can carry significant weight. But more importantly, it's where you get the very project-specific definitions that have been drafted sometimes specifically for that project. Those are the ones that you really need to check. And at the same time, to check whether or not there are hanging definitions, whether or not there are definitions that don't go anywhere, aren't used, or conversely, whether or not defined terms within the body are not actually included within the defined terms, because this is a perfect opportunity to create uncertainty one way or another, or indeed go into an area where you hadn't intended. Now, the fourth area is the core provisions. Now, these are the clauses that shape the core risk profile of the EPC contract. They are the core provisions. And again, this sounds pretty obvious, but instead of reading the whole contract, I will go, having looked at the contents page and looked at the headings, try and work out where the essence of the EPC contract is found. They're often, strangely, not the focus of the negotiations, but they're amongst the most consequential in practice. And these are the clauses that are primarily intended to reflect how risk is allocated, how performance is defined, and how the contract responds to change. Now, my general list of core provisions is 1, the contractor's performance obligations. You'll normally find this, strangely enough, it always seems to be in clause 4, but you'll normally find this, and setting out what the contractor is required to do in the most succinct terms. I will also look as part of this in terms of the contractor's design risk, the allocation of risk of ground conditions, the question as to whether or not the EPC contract uses the concept of rely upon information. My fifth one in this list is about permits, licenses, consents, who has responsibility for these. And my sixth one is change in law. Now, each of those is a topic in itself, and we could go on. But actually, if you can get it in your head, and when you're approaching these things, that there are thinking about what is the essence of this project and where are the key risks in that way to be allocated, then it gives you a good sense of how to review the remainder of the agreement. Because it's ultimately about what is fundamentally intended, but not necessarily achieved. Now, all of these provisions can be read to see if they achieve their aim in detail. And each of those, as I say, is a topic in itself. If we're thinking about design obligations, we're thinking about whether or not the contractor is responsible for full design, or is it based on a feed or employer-provided concepts? Does the contractor take the risk of errors in that? Is the contractor expecting to be taking the risk of a third party that hasn't had an opportunity to review or hasn't had the time to review the detail of their designs? And where we've got proprietary information, often that can be a black box. That should raise a question as to the allocation. Performance standards. We have the inevitable discussion about fit for purpose or detailed performance specifications. Now, fitness for purpose obligations can significantly expand liability, especially under English law, whereas at a core, a purist EPC contract will be just looking at very clear performance specifications. And misalignment there can lead into greater issues. Rely upon information is relatively self-explanatory, and indeed ground conditions, people will understand those. Change in law is quite important, and I'll come on to this a bit later on. Now, these provisions are where the contract's commercial and technical realities meet the legal framework. I will always have a look at those very early on, because they will tell me how the parties have approached the risks, the core risks, and reveal the fingerprints of where the driving seat is. Now, number 5, the devil's in the schedules. So when we're talking about EPC contracts and conditions, and I talked about up to 100 pages, 150 pages of conditions, that's obviously at the front. Above that is often a project agreement. Behind that there is almost invariably going to be a number of schedules. Now, don't ignore those schedules when you're doing your tender review, when you're doing your initial review, because it's very easy to treat them as appendices or secondary documents. But often in an EPC context, they contain the critical commercial and procedural detail. And the sort of things that we would normally expect to see in an engineering contract have been moved into these schedules. So in addition to things like scope, you may have the change procedures, you'll have payment terms, you'll have pricing, you'll have the time schedules, you'll have liquidated damages. Now, the key here is to ensure that the schedules align with the main contract. And discrepancies between the body, the conditions, and the schedules can lead to, and often do, lead to confusion where there are conflicting interpretations. Now, how do you approach that? How do I approach that? Well, what I do quite simply is I will do a global find in the contract as to referring to schedules. I'll make a list of those schedules, I'll work out what they are, and then I will go through the document, often looking for the word schedule. Sounds obvious, but making sure that we've got those points and writing a list of things to be looking at to see, okay, I'll have a look at the change provisions. They're all in the back. We'll have a look at that. This is really important, because sometimes you need to read the schedules in detail before you read the whole contract. Now, number 6, the world of indemnities. Now, indemnity provisions as another good indicator of what I think is the sophistication of the drafters and the parties who have led this. Now, when well considered, they can reflect a nuanced understanding of risk allocation. But too often, indemnities are used or can be used inappropriately, or dare I say, lazily, as a catch-all solution for issues that actually probably demand more thoughtful treatment. It's often seen as a shortcut. They're deployed to plug gaps to avoid difficult conversations about liability, and rather than thinking about the specific risk of that project. Now, it's fair to say that indemnities are a staple of EPC contracts, but they probably remain one of the most misunderstood of these legal mechanisms. From an English law perspective, indemnities were originally used to allocate risk for third-party losses. For example, claims arising out of intellectual property infringement, personal injury, or damage to third property. Now, in an offshore context, they've obviously been they've come in, and we now use the knock-for-knock regimes, and that's designed to simplify the allocation between the contractor and the owners, the company. Now, whilst these regimes sometimes are treated as expectations, they reflect the broader principle of indemnity as a tool for risk transfer. Importantly, over time, I've seen that the use of indemnities has expanded, and increasingly they're being deployed to cover direct contractual breaches, often, it seems, under an assumption that they offer a more straightforward or comprehensive route to recovery. Now, that assumption deserves scrutiny. And again, it's an area where I've given many talks to clients on about the understanding, the interreaction between indemnities, insurance, and limitations of liability. Now, under English law, as a general proposition, indemnities do not automatically override standard principles such as remoteness of damage, unless there is explicit drafting. However, indemnities are triggered by loss and not necessarily breach, which means that they can have an ongoing effect. So when I approach these things, I make a point of identifying every single indemnifying provision. Again, using a global find, a global search to identify the language. Sometimes you can, from a very practical perspective, just search INDE M N and then run through the document to see when the word indemnify has been used. Sometimes different languages being used, hold harmless and the likes. List them out, look at them, think about where it's going. Now, this is not because these are necessarily a bad thing, but again, you need to understand where they are being deployed and whether or not it gives you an indication of uncertainty or lack of confidence that there are the rest of the operative provisions which are there to help you understand the fundamental scope of these things are not considered sufficient. And you see these things buried in clauses such as the compliance in laws clause, data protection, environmental liabilities, failure to insure. And again, that's not necessarily a bad thing, but they need to be put into the context of those other obligations. Now, moving on to the next one, which is applicable laws, and when the law means more than the law. Now, this is one of those clauses that can look straightforward, but often isn't. And just over many years, I've realized that it's absolutely key to spend some time, particularly before you dive into that detailed review, to think about the definition of applicable law or applicable laws, because rarely it means what it says or says what it means, in the sense of it's really not just about the governing legal system. It can involve non-binding standards, industry recommendations, classification requirements, flag state requirements, guidelines, codes of practice. Now, this is on top of the specifications, the detailed performance specifications, which has already been set out in another document. And this can blur the line between specification and certainty. Now, if the contractor is required to comply with standards that aren't legally binding, it raises questions as to, well, what happens if those standards change midpoint, and are they enforceable? And do they create obligations that go beyond what was actually intended? Now, some change in applicable law clauses will deal with these things, others won't. And so you really need to think about it. This is specifically relevant in sectors such as nuclear, offshore, and marine, where you have the regulators are developing and imposing requirements that are evolving over time. And where the contract doesn't clearly distinguish between what is binding and discretionary and how to deal with the uncertainty that creates, it can cause difficulties. So I always ask myself, is the definition appropriate or too broad? Does it include non-binding instruments? And is there a mechanism to deal with those changes in standards and recommendations that aren't which aren't binding? Now, the next one is changes, and I always think, when I'm thinking about change clauses, about David Bowie's song. And I think one of the distinctions you often see with EPC contracts moving away from perhaps a FIDIC approach is that there's often different language being used. They're called changes as opposed to variations, but also the change provisions have a much wider scope. They often don't just deal with changes in scope, but they frequently double up as a mechanism for the handling of claims, whether for time, money, or both, and for general relief. Obviously, in a FIDIC contract, you have the separate provisions with the claims clauses and the variation clauses. But it's important, I think, when I'm looking at them, to identify where those provisions are found, and again, to then use that as an opportunity to assess and to role play certain scenarios as you go through the detailed contract to work out how those change provisions will work. And the questions I ask myself are, are the procedures clear and practicable? Can the contractor comply? Can the owner comply? And particularly in terms of things like the notice requirements and the substantiation requirements. And often bearing in mind that leading into EPC, when the EPC contracts, when they're being signed, is that there's often an early design, a pre-design stage where the contractor has had a lot of opportunity to be thinking about the risk involved, preparing its design and pricing them. Now, when you've got change procedures that don't recognise that and require the contractor to come up with give notices and give substantiation and give details in a much more abridged period of time, that can create a tension. And so you need to think about whether or not these are clear and practicable. Is there a defined mechanism for resolving disputed changes, which again is important? What happens if things can't be agreed? How are things going to be resolved? Because potentially the money that is involved and the time implications that are involved can be very significant. Generally, and this applies not only to change provisions, but also to the EPC contracts generally, are the time periods for notification and response reasonable? Are they achievable? Because often you're getting very tight timescales that may not necessarily reflect the realities of complex contracts. And so you have to think about whether or not which way to go. And also whether or not there is a distinction between variations and claims in these provisions. Because sometimes they don't distinguish them, which can create a little bit of uncertainty as how they'll be operated. Now, in number 9, I've got certainty, but involving third parties. Now, again, what I try to do when I'm going through at an early stage is to identify all the potential third parties who may be involved, who will want to view on things, and who the contractor might have to comply with. Because often you'll find that the contractor scope could be subject to third-party approvals, such as the Marine Warranty Surveyor, regulators, classification societies, flag states. Now, these approvals can be framed as a condition precedent or post-completion requirements. Sometimes they're even marked as to be TBC, to be confirmed, or left undefined. Now, that to me raises an immediate flag. So what exactly is being approved? What is the scope for these third parties who aren't parties to the contract to influence the outcome? And what happens if the approval is delayed, denied, modified? How does this affect the contractor? And the key is this works both ways. This is not just a contractor side thing, or this works both ways for the employer and for the contractor to understand where it is the delineation of responsibility as to defining scope, and where there are contracts that have a lot of things that are subject to third-party approval, and that approval and the scope of that approval hasn't been defined. It requires some further consideration. As an added point, again, you will commonly see that the employer and the employer's nominated people will have broad rights to have access to and expect the work of the contractors, the subcontractors, and sort of supply chain. Now, these rights, if overly broad, have the potential for causing disruption to the contractor. Conversely, they're there for a very good reason, particularly to protect the financial interests of the lenders and the funders, to ensure and to monitor the work that is going on. But there is a potential where these rights are so broad that they could start to interfere with the EPC type idea, which is the contractor has this single point responsibility. Now, in number 10, I've got boilerplate clauses. Now, these are not merely the small print, as I've said. Now, boilerplate clauses, as many people know, are often found in 5 to 10 pages right at the end of the contract. And certainly when you've been reading through a contract, and I've been reading it through for 6 or 7 hours, and you get to the last few pages and they all look very familiar. Oh, it's just the boilerplate. And unfortunately, the boilerplate is, I think, is a bit of a misnomer, because whilst they're really rarely subject to negotiation, they can fundamentally shape how the contract operates. And it's often the point where disputes lawyers will go back and will be looking through in order to see whether or not there's an opportunity to frame something in that, if they can't find something in a substantive provision elsewhere in the contract. And some of them may seem like routine, like entire agreement clauses, pretty standard, but you need to make sure that that is an appropriate entire agreement clause. Another one is exclusive remedies clauses. Now, if there is one, it requires a detailed review of the contract to ensure that all the remedies are included, and if not, to try and get them written in. If not, it can come back to bite you later. And obviously, you pay particular attention to things like the governing law, language, and notices. But before I've done that really detailed substantive review, I will have gone back to read those boilerplate clauses in order just to make sure that I know how that contract is being framed. And then after that, there's everything else. There is a very long list, as I said, of substantive issues which we will start working our way through. Here is an example of some of those, and it goes on and it goes on and it goes on. But the 10 that I've referred to are the ones that I go to immediately in order to set the scene, to understand them, to work through, to provide my framework for review, to get a bit of that, get beyond the intuition, to get an educated and informed decision as to whether or not I'm going to have to really concentrate on the individual precise wording of key clauses, or whether or not my focus to start with should be looking as to where all the surprises might be, or the things that might be slightly unusual and unconventional to work your way through. Now, this is my top 10. And as I say, this is something which is something that is quite intuitive to me. And when I was preparing this talk, it took me a long time to get down to 10, I have to say, because every time I got into these things, I realized I was getting into the detail. I obviously spend time looking at the liquidated damages provisions or the delay penalties provisions. I will make sure that I understand the full overview of the security provisions. But once you can look at these, you both get, well, for me, I get a very, very good sense as to the overall risk profile, the attitudes of the parties from both sides. And as I say, this works absolutely in both ways, from both sides. And it allows me to make very informed decisions early on as to where we're going to go. Because when I went back right at the beginning and saying, well, it normally takes me 6 to 8 hours. Well, the key here, and you can fall into that trap, which is, oh, it normally takes me 6 to 8 hours, therefore it takes me 6 to 8 hours. When I've spent an hour and I've gone through, and it'll probably take me an hour or maybe slightly less to work through all of those points, I will then be in much better position to say whether or not it's going to take me 6 hours, 10 hours, 20 hours, because I've identified where the particular specific risks that you need to be thinking about. Now, it might seem, well, hang on a minute, you haven't told us anything about risk allocation and things like that, and at a tender stage. But again, and I've struggled, I have to say, to try and put this into words. Why are these important and not other things? But for me, these are the biggest indicators of where we're going to get to, having done the detailed review. And so when I'm at that initial stage and picking it up and getting that idea as to where we're going to go, what does this look like? It goes there. Because beyond that, inevitably, you get into involving issues which are much more project specific. Who are the parties? Where is the project? what is the environment in which you're going to be dining on. But that's all part and parcel of the tender process that you will have been gone through. So that's my top 10. It's been an absolute pleasure to share this. Hopefully, you might have some questions. If you do, please do try and see. We can see if we can get the Q&A function to work. If you don't have any questions, we will bring it to an end. But I'll give it a moment where we can see if there's any questions. Do I also have one of the questions that's just come is, do I have a list for possible missing clauses and principles? Now, this is a great question. I do. And again, when you're reviewing these contracts, and in fact, any contract, but certainly a contract where which has been consolidated in a sense of you're being given a condition that run from 1 to whatever number, as opposed to something that is a very, very clearly amended contract. So you've got a set of general conditions and particular conditions. One of the things that the challenge you have is not only to go through and to work out what the contract says, it's also to go, well, what does the contract not say? What would I expect to be seeing in there? And again, that sort of goes back to when I was talking about looking at the contents page. You can get a pretty good idea as to what's in the contract by going through and looking through the headings and these sorts of things. And then I have, and as I say, I can wave a piece of paper in my hand here. It's a list of clauses. And so one of the points that I would be going through when I'm looking at that contents page is going through and thinking about, well, hang on a minute, we haven't dealt with this. A really good one, okay, a very easy example that sometimes that quite commonly comes up is in offshore construction, and someone has adopted a land-based contract, and so there isn't anything that deals with vessels. Or vessels are being treated as equipment. And there's nothing about the latest vessel availability date. The definition of site becomes very more complicated in that. So I have individually those clauses which I would expect to see. But it works the other way. And I think that's the other thing, is it does work the other way in the fact that sometimes you're finding clauses that are inappropriate. Again, from an offshore context, thinking about the definition of the site. And when you've got provisions that say that the contractor is responsible for security of the site, and the site is a wind farm, which covers hundreds and hundreds and hundreds of hectares, well, what does that actually mean? I produced that, and again, I produced it over time, over many years, to come up to do these things, and trying to have a little bit more. And I suppose this is probably these things that I wish I started writing that list when I first started 20 years ago, to be identifying all those clauses. I've got a pretty good idea as to where they are now. I've actually got to a point of just writing these things down as individual headings. Hope that answers the question. So the next one I've got is, what are my thoughts on NEC 4 versus FIDIC, which one in your bed is better drafted EPC, or do you prefer bespoke contracts? Now, it's interesting to say that, because the NEC, which is a UK-based form, or certainly UK originated, produced in the late 1990s. It's it's drafted in a very, very different way from the traditional conventional construction contracts, and certainly those with an Anglo-Saxon origin. NEC contracts are very short. I've got somewhere around here, but they're sort of 20 or 30 pages. with a few options that you add on. Whereas FIDIC now, I think the current FIDIC form is, I think 1999 was about 80 or 90 now. The 2017 is well into the hundreds of pages. And they take a very, very different approach. NEC recently have been giving webinars and training on using NEC NEC4 as an EPC contract. Now, the difficulty I have, and it really is a very philosophical issue, is the fact that the NEC form, the way in which it's drafted, doesn't necessarily provide the same certainty that one would expect to see in an EPC contract. It's using present tense. It's very, it can be said to be, it's very forward-looking. It's very much directed at good project management rather than going back to the previous slide, creating that very clear box of obligations and responsibilities. With that said, it can be used very effectively on the right projects, but more importantly, with the right team. And indeed, I've got a number of clients who absolutely love using NEC contracts. However, particularly where you've got funders involved, it's more difficult. I had an example a few years ago, was it last year, a couple of years ago, where I was having to explain to funders how NEC works in order to come up with something that was bankable. We got there in the end, but that required a different assessment of the risks that were involved than what one would normally expect to see. And so there are lots of different approaches. I think often you're seeing that, so I would probably, out of NEC or FIDIC, I would probably tend towards FIDIC, only because it's normally going to be more acceptable with appropriate amendments for funders from an EPC contract. Bespoke, again, it depends. Sometimes, and particularly where you're talking about particular industries, and it's the nature of, because it's the nature of standard forms, is they're trying to provide effectively a one-size-fits-all contract that fits multiple different industries and from a FIDIC perspective all over the world. Now, actually, when you're looking at those FIDIC contracts, is it actually better to amend them, or is it better to start from a bespoke contract? As I said, not necessarily something that's brand new from a blank piece of paper, but something that you start from and build up. Because I think the problem we have sometimes with FIDIC is it's a case of amending something which wasn't intended to be used in that way. And whereas with a bespoke contract, you have full control over all of the core clauses. I have no particular precedent, but again, when we come down to the idea of contract selection, that is a complex issue and involves multiple aspects. It does sometimes it requests who is the market, who is in the supply chain. Are they willing to supply and sign up to a bespoke contract, or do you need to put have the FIDIC on the front in order to attract the right tenderers? But in certain industries, there is, I'm not sure many people know, in certain industries, you get into a sort of an orthodoxy as to the way in which work is being done. Certain industries will use an amended form of the FIDIC Yellow Book in an EPC's way, and that's understood as the way in which it's done. In other industries, you would more usually, particularly in things like when I'm getting into process plants and petrochemical, I'm more likely to be seeing bespoke contracts or what we say bespoke contracts. Amongst friends, here's an interesting one. How long do I think we have until AI will be able to do a meaningful initial review? I think we're already there, to be quite honest. And that will probably scare anybody. I think we're immediately there because there are these tools out there now, and they are a tool. And I think you need to be slightly careful about when we're talking about AI, because there are tools that have been around for a number of years, which are in many ways proofreaders. These are the ones that are checking for typos, checking for hanging references, checking for definitions, checking for completion. Now, to me, and because they're not requiring anything that is generative, it's purely analytical. They're fantastic, and they can save you an awful lot of time just to do that. And I'm sure that that some more junior members of the team are very happy about that. At the same time, I should also say that I think sometimes it's a bit of a shame, because that's how I learned that's what my first introduction to a lot of these contracts was, doing the proofreading. And in order to proofread, you need to understand. And often I would use people to say, and I still do it, can you read this? Does it make sense? Because if they don't understand it, we're not necessarily having achieved certainty. Now, on AI, we are starting to see tools that are being doing, but again, and this is an entirely different, obviously a different conversation. I go back to this point about a lot of AI, and it is fundamentally probabilistic, and it requires training through neural networks, and so it depends on the quality of the training and the way in which it's being set up, and so it needs to be trained on good quality source material, and needs to be shown what is good and what is bad. And the problem is sometimes you can get lost and you can end up repeating the same mistakes because it's what everyone has always been done. But as I said, I think there are tools that can already do that. But the strange thing is, how do you then check? And I think, I don't know, personally, I think that we're still a long way off from replacing what I talked about, this idea of this combination of expertise and experience. Because who's checking the checker? Who's checking the AI to make sure that it's right and understanding this? Who is taking that holistic view to do that? And now I will still have to, and I would still say to clients, if I'm talking to them, I still want to read the contract, even if we put it through. It will tell me, and I can feed in all of my heuristics as to where it's going to go, and I can probably train it in this way. Things like contents page, length, all of that sort of stuff. Doesn't take me very long. It could be done immediately using technology. It can pick out all of these, the indemnity provisions. It can pick up. So all of this can be done incredibly quickly. Now, the hardest thing is then to apply what I describe as the human element. And because the new COO of FIDIC said this a couple of weeks ago, is that the engineering and our industry remains very much a people industry. There's lots of things being built and lots of equipment being used, but it's still very much a people industry. And it's about understanding how everything will fit together and understanding how individuals will interpret those. And that, I think, is where AI doesn't necessarily get us there yet. But it can save us a lot of time to focus our attention in certain areas. So I'll leave it for about another 30 seconds in case anybody else has got any other questions. And then I think I will... and if they don't, I will call it a day. I've managed to keep it within under an hour, which I'm pleased. I hope you found it interesting. It's certainly been an interesting exercise for me to work out what it is, but more importantly, why I do things. And I think the big takeaway for me, beyond the top 10, is to come up with your own one. And if you don't, and obviously there are people who don't necessarily have the experience that I've got. So how do you get the experience? Think about it in this way. Think about the way in which you're reviewing. Learn from those experiences. Learn about the points that you're trying to find and the issues that keep popping up. And because that really does give you a shortcut to a lot of these things, which, whilst no substitute for a detailed review. There you go. I've said it again. Whilst it is no substitute for a detailed review, it does give you a very good indication early on as to where you're going. This applies from everybody involved, from an owner and employer. Coming to me, you can go back and say, well, actually, hang on a minute, where are we going? Are we clear on where we're going? From the contractor, are these the risks that you want to do? This is a good indication as to the other side's approach, the owner company's approach. From insurers, length, complexity gives you a very good indication as to how the potential behavioural issues that might arise during the course of it. And equally, for lawyers and experts and consultants, a really good insight into, is this going to be a roll up the sleeve every point we need to take, or is there a general consistent overview? Because that enables you to have much more confidence in your conversations and clarity in your conversations in order to achieve ultimately what is in the interest of everybody, which is an asset which is built on time and on budget. So thank you very much, everybody. Enjoy the rest of your day, and I hope I'll see you all soon.